Folks, welcome to the people in the room. Glad to see happy faces. Glad to see it didn't snow on the way here. We're talking about a topic that's a little different today, and we've got several folks from Gray Plant Moody, different offices, that I'll introduce a little bit, that people can say a little more about their own selves and practice and experience in this area when it gets to them. A couple housekeeping things, feel free to ask a question. If we don't have time for questions, I think our folks online can register a question in the chat section of the webinar. We're having trouble with audio, Chris. We're seeing a that says I can't hear it. Yeah, just a second, guys. Technology. I recall one time having I recall one time having Bob Harding, speaking with Bob, but he was just on the screen. And so we were sort of ironing out the technology with that. It was good and bad, ultimately kind of worked. I thought he should pretend he was the wizard from The Wizard of Oz and have some smoke and stuff here, but we didn't do that. So hopefully Chris will fix our audio issues, because that's important. Otherwise, it's just slides. Give us a second, guys. We'll talk fast. Catch up.
Hannah, I'm going to run over there and see it.
Do we think others?
Can anybody else hear us on the webinar?
Just understanding how the industry has changed so much.
Okay, great. All righty. So I'm Cheryl Morrison, and I'm here at Gray Plant in our Minneapolis office with, my practice is trust and estates, and then I have a toe in the nonprofit arena, working with nonprofit clients on their charitable giving matters. And so today we're going to talk about sort of charitable giving and how that fits into management and operation of gifts and, even your organization more globally, in the context of concerns about bankruptcy and financial distress and tort liability. So it's kind of a developing area that Phil will talk a little bit about his experience, or a lot about his experience in this area, because he has a lot. Phil Kunkel is from our St. Cloud office, and his practice is in the bankruptcy area. And he's been mired in the Catholic diocese bankruptcy issues in his practice. So he'll talk about that. And what we really want to bring you today is some learning that comes from those cases that Phil has been working on, where we've been collaborating, because there's, sort of the nonprofit management issues and separate foundation issues and gift issues that come up. So, and then Sarah is former managing partner, that's not the right word, but has headed up our nonprofit group and does a lot of work with nonprofits on governance and structural aspects and management. So they'll talk more about their practice, but with that, Phil, do you want to just jump right in?
Sure. Thank you. Thank you, Cheryl. Yeah, we don't want to frighten you right out of the chute, but we probably will cause you some concerns by the time we're finished. My background, as Cheryl mentioned, is I practice rights arena. For the last 5 years, probably, we have been working with a variety of primarily Catholic foundations throughout Minnesota and across the country. In addition, we have worked with other Catholic entities and both in planning, well, in anticipating potential bankruptcy cases to be filed not by foundations, but by their supported organizations. And so I think it's safe to say 5 years ago, I did not know what a donor-advised fund was. And I suspect 5 years ago, Cheryl and Sarah didn't know what substantive consolidation was. So we've taught one another quite a bit about our respective areas, and we managed to assemble a team that's, I think, pretty unique across the country in terms of having the skill set assembled in one firm. So with that, let's get started. What we want to try to accomplish today is I want to introduce you to some basic bankruptcy concepts initially. I assume most of you have never had to fight your way through a Chapter 11 case. That's a good thing. It's not something you should aspire to. We also want to talk a little bit about how a bankruptcy filing by your supported organization. And when I use that, I know that's a term of art and I don't mean to convey anything, but Sarah's taught me that too. But how a bankruptcy filing by, for example, a Catholic diocese or your primary grant recipient may affect your operations if you're separate from that entity. And then throw out some ideas on how best to prepare. So that's an ambitious agenda. We only have an hour, so we will try to move as quickly as we can. The first point to emphasize is when you hear of a Chapter 11 bankruptcy, it's important to remember that a Chapter 11 is not a liquidation. Chapter 11 is designed to permit the debtor to reorganize or restructure its operations. The debtor will remain in possession of its assets during the Chapter 11. Business as usual will pretty much continue as usual. For example, employees will continue to be paid, employee benefit plans of the debtor will continue to be funded, health insurance, so on. There will be a few limitations on what the debtor can do without court approval, but for the most part, operations will continue as they did pre-petition or pre-bankruptcy. Generally, secured creditors will retain their liens or security interests on assets. Unsecured creditors will be represented by a creditors committee. And so the debtor will deal with a smaller group of unsecured creditors in managing the case and attempting to restructure its operation. Other related entities can be pulled in inadvertently or informally. And that's where if you're a foundation where you can be implicated whether you want to be or not. And so that's what we'll talk about a little bit in terms of how do you get ready for that.
I'm just going to jump in and state sort of an obvious, but just to clarify, since most of us don't work in bankruptcy world, the debtor is the organization that actually filed for bankruptcy.
Right.
So.
Oh, sorry, yeah.
And the creditors are people to whom the debtor owes money.
Fundamentally, a Chapter 11 involving any nonprofit establishes a system, a process, a structure for negotiation. A deal will have to be reached with all of those creditors, with all those parties. In the tort cases, such as the Catholic cases or USA Gymnastics, for example, has filed in Indianapolis recently. Everyone is waiting for the Boy Scouts to file any day. In cases like that, the negotiations will involve the debtor, the diocese, the organization, the creditors, the tort claimants who are out there, any third-party foundations or supporting organizations that may be out there, and insurance companies who will have provided coverage for those tort claims. So the cast of characters is pretty broad. For example, in the Archdiocese case here in Minneapolis, I think there were something like 37 or 38 different insurance companies involved. So it's a good opportunity for bankruptcy lawyers, but not much else. So bottom line there is that it's a reorganization and negotiating process. Got ahead of ourselves here. The objective in a Chapter 11 is to negotiate a plan and to figure out a way to deal with those claims. Chapter 11 offers several advantages for the debtor. It stops any pending litigation. So to the extent there are tort claims pending, those will come to a halt. It will provide a mechanism for distributing assets. It offers advantages for creditors too, although creditors never want to talk about that. But it basically, the stay that is imposed on the litigation offers advantages for creditors because if that didn't happen, distribution of the debtor's assets would depend upon who wins the race to the courthouse. So it allows for more equitable distribution. It has some significant disadvantages though as well. It's time consuming. If you're trying to negotiate with multiple insurance companies and multiple creditors, it will take some time. It's expensive. It carries with it some potential adverse publicity that I think maybe we'll talk about that right now. If you're involved in supporting an organization that could find itself in a Chapter 11 case, I will promise that you will receive questions from your donors, your grant recipients, maybe the press. Your board members will be asked questions at cocktail parties or receptions, and you need to be prepared not only for the legal aspects, but for the communications aspects from day one. And Sarah will be talking more about that later. At the end of the day, the debtor has to propose a plan. And the plan has to how the claims will be paid. And generally, that's going to require the debtor, which is, after all, a nonprofit, to monetize virtually everything on its balance sheet. And that means it may be required to liquidate assets. In the Archdiocese, again, the Archdiocese of St. Paul sold its office building, the Chancery Building on Summit Avenue. In the Duluth Diocese case, which was just confirmed a couple of weeks ago, we're in the process of selling the bishop's residence to raise cash to fund the plan. The debtor will use most of its cash reserve. It may have to go out to its donors to try to raise funds from its donors. It may look to third parties, like all of you in this room, to help fund a plan going forward. That may take a variety of forms. It may be an out-and-out contribution. They may ask a supporting foundation to extend credit. We'll talk a little bit about that, to make a loan. It may be a combination of both. It may be payments over time. I'm a bankruptcy lawyer, so that means all the rules get thrown out the door, and I have to argue with the nonprofit types to tell them that we need the money. I don't care how we get it. And then finally, we got the insurance proceeds or a possible loan. So that's sort of the overview of a Chapter 11. And with that, I think Cheryl's going to talk a little bit more about how various types of funds may be affected.
Right. So we're, all nonprofits and folks who deal with nonprofits. And so the question arises, Phil talked about monetizing all of your assets. How does that affect the various funds that you might hold? Sarah's going to get a little bit, when she starts talking a little bit more into sort of practical structural things. Phil referenced the concept of the debtor. And it may be, if it's the YMCA, right? That could be the organization. You could have a separate foundation that's a supporting foundation as well. And Sarah will get into that. But whoever is the debtor or another party that's being looked to satisfy some of the obligations or liabilities. The question becomes what funds might be available to do that. So let's talk a little bit about, I suppose I have to put my glasses on to see where we are. Sorry, okay. So let's talk about some of the kinds of funds that you may hold and how those might be affected. You know, just based on some case law that's out there and Phil's work in this area, if funds are restricted for a purpose, donor restricted for a purpose, we think those funds may more likely be successfully argued to not be available to satisfy the general creditors of the organization. So if you think about your funds that you hold, you have maybe general operating funds coming from annual contributions. You might get distributions from your endowment or spending money from your endowment into your general operating fund. Your general operating fund will very likely be available to satisfy creditors. But if you have a donor who gives a gift to you and the donor has restricted that gift for a purpose that's not your general operating fund, we think that a bankruptcy court will more likely respect that donor restriction than if the fund was not restricted to purpose. When it comes to board restricted gifts, so you might have gifts that weren't restricted by the donor, right? They just came into you without a donor restriction, but your board says, well, we're going to set aside these funds to use for this, or we're going to set aside these funds into endowment, for example. Or in some cases, as we've seen, the organization maybe uses its separate foundation, right, or the supporting org that it has to be its endowment. And so the organization says, when we get a gift of this kind or this magnitude or this structure, we're going to put that into this board designated endowment. When you think about that kind of fund, it's the board making the decision with respect to unrestricted funds. The donor hasn't said anything about that, but the board is saying, let's set that aside, or let's transfer that to the foundation and let the foundation manage it. Those kinds of funds we think are more likely to not be protected, if you will, and to be available to satisfy creditors. Because if you think about it, it's the organization who's placing these restrictions. There's no outside person really doing that. So in terms of those kinds of gifts, let's think about some that might be in the gray area. What about gifts that a donor says, I want to be endowed? No purpose stated, but I just want it to be an endowment. So, you know, the organization can take the 4% or 5% or whatever the spending policy is and use those funds for whatever it's using them for. That's probably a gray area. Phil can comment more when he talks again on some of the practical aspects of this, but the bankruptcy code has, you know, it really defers to kind of state law as to the character of property in general. And so something like that might be something where the bankruptcy court would say, if the organization can get at it with respect to the spending amount, you know, the organization maybe can't get at the principal if it's truly endowed. But if the organization can get at the spending amount, the creditors may be able to as well. So whatever the organization sort of has a right to for its general purposes would be something that the creditors committee would say would be available. Donor advised funds, what about those? Again, if there's no real restriction based on the purpose of those funds, and it's just the organization sort of holding them and letting the donor make advisory recommendations about what the fund is used for, really the organization still has complete control over those funds and what it uses those funds for. That's probably in the gray area as to whether those are protected or not. This is really a developing area of the law. There is case law out there that says that if a donor has stated a restriction on a fund, that is to be respected, even over the rights of creditors. Yeah.
If you talk about a donor-restricted fund that the debtor organization controls, people donated to it, or funds that the debtor has placed into a donor-advised fund at some other foundation?
So your first example is where I, as a donor, say, I'm giving you, the debtor, this money to use for X. There's a specific purpose stated. We think that is likely to be protected because of that donor restriction. Now, if you are a debtor organization and you have taken funds and placed them somewhere else, so for example, you're somebody in southern Minnesota and you place funds at the Community Foundation for management type purposes, I think those are going to be considered your assets if you are the debtor and in bankruptcy. Just because you've placed them somewhere else or invested them somewhere else doesn't put it beyond the bankruptcy.
You would be told to advise the holder of the funds to get back to you.
Right, right. It's because you still have the right to those funds, right?
Well,
So,
I'm going to jump
yeah.
in though. It really depends on there's a couple of ways, and these are all areas where there isn't case law that has specifically, so we're analyzing how do we think a court would evaluate it. So some community foundations, for example, set up an agency fund where the agency has the right to withdraw the funds at any time.
Okay.
I think from a bankruptcy perspective, that's like a bank account, right? So yes, those are assets of the agency that then is the debtor.
And there is case law, bankruptcy case law on those types of funds.
So, but there are also times where you set up what I think is often referred to as a beneficiary fund, where you actually given up title and the right to withdraw, and they now are the assets of, in my example, the community foundation. They may be restricted as to purpose that aligns obviously with the purpose of the organization, but the organization no longer has the right to demand the control. Those are less clear, but there's another concept under bankruptcy law, which is if you're giving your assets away in anticipation of bankruptcy, they get clawed back. And so it may depend on the time frame and how recently that fund was established relative to when the bankruptcy was filed. And if it was 20 years ago, it's going to be a much stronger case that it's no longer the asset of the debtor and can't be reached. But if it was yesterday, likely it's going to get clawed back.
And just real briefly, an additional comment with regard to transfers by the debtor like that. These days, I can guarantee you that if the debtor files a Chapter 11, you will have the opportunity to go through your files and find every email, correspondence, telephone record, bank account record relating to those transfers, going back to the beginning of your organization. So you may be able to win, but it's going to be a tortured past.
Right. And so those are good distinctions and good comments. And as Sarah said, this area is really developing. In some cases, there are actual case opinions out there, and in other areas, we're sort of extrapolating from what we've learned in these cases that are going on out there. Yep. Oh, thank you. So I can't do technology and speak at the same time. There we go. So when you think about that issue of all of the property of the organization being subject to creditors' claims, you have to look at these questions of what funds do you have? How are they structured? When were they created? How were they created? What are the legal and beneficial rights with respect to those funds? Sarah made a great distinction between, a fund that is an agency type fund where ownership really doesn't transfer, but if it's more in the nature of a beneficiary account, the actual ownership and control has transferred, and does that make a difference? And so you would have to look at your own funds to sort of think about how this issue affects your organization and the funds that you hold. This just confirms that, if you've got a donor-restricted fund that, again, the donor has stated what the purpose is, it is likely that bankruptcy courts will respect that and will respect the donor's right to limit the use of those funds. You know, it may be that, as Phil mentioned, you may not succeed on that argument just by making it. You know, it may be a painful process to get through those arguments and negotiations around, you know, what the nature of the fund is. But in general, we think that that kind of argument has the most likelihood of success in a bankruptcy. Yeah.
So I'm guessing what you're talking about is any kind of gift documentation that you had, including emails, including this, that, and the other thing.
Right.
Where does kind of non-official gift documents fall into that play?
Well,
such as email, or such as kind of letters that they wrote about what they think they might do.
Obviously, the best practice, and we'll just zoom right to that.
Oh, okay. I'm thinking about it ahead.
Yeah, I'm going to skip some of this here.
Well, Cheryl's looking for that. I mean, Cheryl and I worked on a case a couple of years ago where we were dealing with a situation with an 8-figure gift to a nonprofit facing multiple child abuse claims that we weren't aware of until well after the fact. I think it's safe to say we tried to find any evidence of the donor's intended restrictions on purpose in emails, notes, correspondence, documents. We talked to board members. We talked to management of the beneficiary. I finally told the lawyer who contacted us, give us something to hear. Unfortunately, we couldn't. But,
Right.
Right. The case law is pretty good. You know, there are some bankruptcy cases that say that if you can find evidence of donor restrictions anywhere, most courts are likely to recognize that.
And we're not talking organizational intent to use the money. We're talking about specific donor intent.
I think that's, you know, my friends sometimes tell me that what I'm involved in is hiding assets. You know, I like to think of it more in terms of recognizing and giving effect to donors' intentions.
Right, right. And so best practices, of course, are to have clear documentation around who's restricting the gift, what are the restrictions, and making that abundantly clear in your gift instruments. And we recommend using gift instruments where you've got a restricted gift that are clear and state very explicitly what the purpose is and that the donor is restricting that gift. Under UPMIFA, which is Minnesota's statute governing restricted gifts, the organization has to follow that restriction. The organization is bound by that restriction. And so you know, number one, it's important to be clear so everybody knows what it is. But in this context, you know, having that state law backup for the organization being bound to use that gift for that purpose and having the donor be the one that restricts it, you're squarely within UPMIFA. And, you know, given the bankruptcy views in the cases around that, we think that's what gives you the better chance. So having a clear gift agreement, we think, is really important. You know, kind of the digging around for the evidence might yield some result that's helpful, but it's going to be less helpful than having a written gift instrument. In the case that Phil talked about, assuming we're talking about the same one, it was a gift out of a pre-existing charitable remainder trust. And so think about, as you think about your funds, you may have funds that you are just expecting and you don't either know they're out there or they're, you know, irrevocable, or they're just going to come to you at some point in the future. And so in our case, it was a charitable remainder trust that was terminating and went to the organization, and of course there were no restrictions on that gift in the charitable remainder trust. So what we were looking for was something, you know, in the organization's records that said, okay, I'm giving you the remainder under a charitable remainder trust, and here's what I want you to do with it. So as you think about, you know, your funds, they could be funds that you don't have yet and that are coming to you. And some of these may be really old and don't contemplate these ideas and these problems. Because as Phil said, you know, we've only really started looking at them in the last 5 years.
Well, plus, you know, that, I mean, in the case you guys are talking about, it, I think, became kind of clear what the donor intended was that the gift was unrestricted,
Right.
which of course as development people is, you know, the holy grail. So, you know, and any other time other than the particular situation we're dealing with, that would have been a really positive term of a gift. But
In fact, in that case, my last conversation with the attorney we were working with, I asked him if he could give me anything, and he said, well, I actually have talked to the CEO of the donor here, or the, you know, the entity here, and he said that his last visit with the decedent, he asked him, George, don't you want to restrict this for some purpose? And the response was, I'll tone this down a bit. Heck no, you're losing your shorts. Keep the doors open. So
Right.
that
Right.
wasn't helpful. It wasn't helpful from our perspective. It was great for the recipient.
Yeah. So, as we mentioned, donor advised funds are probably in a gray area. I don't know how many folks in the room have those or manage those. But, you know, again, unless there's some protection or purpose that the donor has stated, which often is not the case with a donor advised fund, we think those are going to fall in a gray area, and you should think about, you know, whether restrictions are something you want to be incorporating into those kinds of gifts. And so with that, Sarah's going to take over and talk a little bit about how these things might come up in practical.
we touched on this a little bit, but the nature and the scope of the risk, and especially when we're talking about gift funds, really will depend on the structure of the organization or organizations that are potentially facing bankruptcy. And one thing I'll mention is that some of these issues these issues have become quite ripe here in Minnesota most recently, but I actually worked on a project in the early 2000s with an organization that was anticipating getting questions like this and concerns because they were starting to experience some tort claims and experiencing donors asking questions. And so we're thinking ahead about how do we manage this? What's the best way to manage this risk? You know, that may never come to fruition, but it's enough out there and there's questions about our organization that we're getting questions from donors, and so we need to be addressing it now. So these questions can come up even if bankruptcy isn't immediately on the horizon. So just, you know, going back to kind of structure questions, as you all well know, many organizations, charitable organizations, do the fundraising and manage their gift funds directly in the organization. So that's one structure. That's, you know, a very common structure in the charitable community, and that presents kind of one set of issues. And in that case, you're jumping right into looking at terms of gifts and so forth. But the other structure is that many operating charities have an affiliated foundation that is then the entity that does the solicitation and manages those gifts, and gifts are made directly into that foundation. That presents a different scenario and a little bit more complicated legal analysis, but another layer of protection for those gifts. So just walking through what those look like. This is the example of an operating charity that, you know, where donors are making gifts directly into that operating charity. And then in our example now where we're concerned about a bankruptcy, there's some kind of usually tort liability, and it's all the same entity. So in that example, you know, the assets of that operating charity, including the gift assets, are now the property of the estate. That then are subject to the bankruptcy rules, and you're jumping into exactly the analysis that Cheryl just walked through of what gifts do we actually have, what funds here are donor restricted, and what portion of our endowment is donor restricted, and what portion did the board, you know, 30 years ago add to that endowment, and trying to parse that out in a way that is, and then, you know, presenting the evidence, obviously, because in a bankruptcy, as Phil described, everything gets approved. Everything gets read by everyone and has to get approved by the bankruptcy court. So it needs to be a pretty robust analysis of whether all those assets and what's our basis for saying that they are usually not available to pay the claims of creditors. The second alternative is that there's this affiliated foundation, and in an ideal scenario, in terms of protecting the gift assets, funds are raised directly into that foundation. that foundation has some kind of relationship with the operating charity, usually a governance relationship, some kind of, overlapping boards, right, to appoint a board. There's usually also some contractual relationships. Usually those foundations don't have their own staff, for example, and they're sort of buying the time from employees of the operating charity. And then we have an operating charity that then, in my example, is experiencing tort liability. In that situation, the foundation is not the bankruptcy, it's not the debtor in the bankruptcy, it's an affiliated organization. So we've got an operating charity that is in bankruptcy, but as Phil mentioned, the foundation's going to get thrown into the mix. And the first layer of legal arguments is to say, oh, no, we are separate. We have done everything right, and we'll talk a little bit more about what does that look like. But we are a separate legal entity. We get the benefit of the corporate shield. The whole reason we have corporations is our liabilities are ours, and their liabilities are theirs, and they're not ours. If you're successful on that argument, and that in the bankruptcy world is called avoiding substantive consolidation, then we don't ever even get to the gift questions because we're not part of the equation for the bankruptcy estate. Now, Bill mentioned earlier, there may be some lots of practical considerations, and one of which might be that the debtor still comes to the foundation and says, help us out, and the foundation then will need to evaluate whether it can, and that would then, part of it would be looking at, the gift assets, the assets that we have, and are any of them available to help our, for the most part, our beneficiary organization, resolve these claims. But our assets are not specifically at risk. If you failed on a substantive consolidation motion and you did get consolidated, then what happens is you're effectively, for bankruptcy purposes, the foundation is treated as part of the charity. And then we're into the analysis of what are all our gifts and what assets are available. So we've talked about this a little bit, but I think we want to turn now to thinking. So what you've got now is sort of the lay of the land of how these issues come up, what are the key kind of legal principles, what's the process. We're going to turn our attention now to, okay, what do all of you in the room and all of you online need to think about? Hopefully you're not on the cusp of a bankruptcy filing, but you're here because there might be concerns that might be coming in the future, or there's just enough of this in the air that you're getting questions from donors, and we want to make sure we're doing everything right to answer those questions and give our donors confidence, even if bankruptcy isn't actually likely for us.
So going then back to, as a practical matter, when you're looking at, let's if you're the foundation and you find yourself in the soup of the debtor because of the consolidation, or if you're the charity, we've talked about that restricted gifts, will likely be respected. But as Sarah mentioned early on, there's a tension between, wanting to get unrestricted gifts to fund operations and do all of the stuff that you do, and that's sort of high on people's minds. And on the other hand, restricted gifts are better in a bankruptcy type situation. So there's this tension that exists between those two ideas. Was looking up in preparation for this, what portion of gifts in the fundraising world are restricted, and came up with some statistics that really show that donors these days are restricting more gifts, wanting to be sort of more in charge, more involved, wanting to focus on areas that they're interested in. So restricted gifts are becoming more common, I think. And so you can see the statistics there as to, what percentage of gifts are restricted versus unrestricted.
As a true bankruptcy lawyer, I made an online contribution to my alma mater this morning and restricted it.
Did you? Good. All right. Right.
I think one thing we've seen, just thinking kind of practically as, organizations have been grappling with this, is certainly if you're interacting with donors who are specifically worried about potential liability, potential tort claims, potential bankruptcy, that would be the donor where the solution is, maybe we have a foundation, let's have a gift made in this foundation, or maybe there's a community foundation that would be the right steward for the gift and you can designate it for our organization, or let's have a really robust restriction on what the purposes of your gift are that would avoid it being used for those things that you don't want it to be used for. It's sort of the conversation with the donor that you probably have every day, but a little bit on steroids.
Right, right. And so, you know, maybe tapping into that idea of restricting gifts, or maybe a different avenue in terms of making the gifts. You know, it begs the question of, you know, if all the gifts forward basis, how do you fund operations? I mean, how do you get to that result? You obviously have to balance these ideas. So the idea of a restricted gift being protected and, you know, going towards a particular mission or program or something that you have, you know, we've had charities who institute policies that say whenever there's a restricted gift, there's some proportion of that that's going to go to general operating, or there's fees that are charged, so that when there's, you know, a restricted gift, there's some mechanism for making sure that there's sort of ongoing aspects of that gift that do go to general operating. All of this is a balancing act, and there's no, you know, sort of one right answer for organizations, but thinking about this issue and thinking about, you know, if tort liability is a concern for your organization, and it's not just the Catholics. Mm-hmm. You know, tort liability can arise in nursing homes, healthcare institutions, any programs that, you know, you're out there working with people. You know, tort liability is not just limited to Catholic organizations. Yeah.
There's also a case pending in the U.S. Supreme Court that actually involves the Catholic Archdiocese of San Juan, Puerto Rico, but the creditors involved in that case were teachers in the Catholic schools, and the claims relate to underfunded pension obligations.
Right.
So, it doesn't have to be abuse claims either.
Right.
Any sort of mass class action type liabilities.
Yep. Yep. So as you're thinking about these things and going into discussions with donors, you know, have these ideas in the back of your head. And again, I don't know that it, you know, controls everything you do. You don't want every gift to be a restricted gift. But, you know, if it's something that's on your mind or a concern for the organization, that's something you should be thinking about. Yeah.
Is it feasible for a donor to make an unrestricted gift, but to attach restrictions, so like a spendthrift trust? So charity, you can use it for whatever purposes you want, except to pay tort claims.
Mm-hmm. Well, and you'll see in our materials we raise that with a question mark.
There is no case that recognizes that, but I have a footnote in a law review article that makes that argument.
Yeah. So again, you know, we'll kind of keep our eye on this area as it develops. And with that, why don't you guys take it from here?
Jump in with one other practical thing as we're passing the baton here, which is thinking about that donor conversation, you know, and the tort liability exposure here is these mass, you know, significant claims that exceed the insurance of the organization. So also, I think arming yourself with an understanding of the organization's risk management program, analysis, insurance coverage, you know, being able to speak with authority around, look, these are the kinds of risks we face. You know, we operate a nursing home. We know we deal with vulnerable people. Here's how we are managing that risk, so that the likelihood of those kinds of claims is lower, I would think would also be a really important part of that donor conversation.
Yeah.
We mentioned substantive consolidation. There's a mouthful at 7:30 in the morning, but let's focus on that, because I think that's the foundation litigation that you want to avoid at all costs. And let's take a step back. The fundamental legal principle in American law is that separate limited liability entities, enjoy a corporate shield. So, the assets of XYZ Corp are not subject to the claims of creditors of ABC Corp. Okay? So that's the fundamental general rule. The bankruptcy process has established some exceptions to that. And there's this doctrine called substantive consolidation. Nothing in the bankruptcy code talks about substantive consolidation. it's a judge-created equitable doctrine, which essentially says that if one corporate entity has taken control of another entity and has managed it and abused its status for its own purposes, equity demands that we consolidate those two entities. And we don't let the Tom Petters of the world, for example, get away with that. And the leading case here in Minnesota involving substantive consolidation actually is the Tom Petters case, where he had a whole series of related entities which were all operated as a giant Ponzi scheme. And the court, the bankruptcy court and the Court of Appeals here has said, no, we're going to roll all those assets together. We're going to pool those assets for purposes of dealing with the creditor's claims. Substantive consolidation is rare, and it's very difficult for creditors to succeed at a challenge. Locally, again, in the Archdiocese of St. Paul case, the creditors committee brought a motion before the bankruptcy court in which they sought to consolidate all of the assets of more than 200 separate Catholic entities, including every separately incorporated parish in the Archdiocese, as well as some specifically targeted entities. There were 3 high schools that were targeted. There were a couple of foundations that were targeted. And the allegations were not well developed, let's just leave it at that. But it's probably the most aggressive attempt to consolidate assets in this area that's been attempted. Ultimately, the bankruptcy court ruled against the committee. They took an appeal to the district court. The district judge ruled against the committee. They appealed to the Eighth Circuit Court of Appeals, which likewise ruled against the committee. And the ruling was very narrow. The ruling was based upon a provision, the provision in the bankruptcy code that permits involuntary bankruptcies to be filed against debtors. And the Court of Appeals ruled that because an involuntary bankruptcy case cannot be brought against a nonprofit, non-debtor entity, that you could not consolidate the assets of all of these various nonprofits. Okay? So it was a very, very narrow ruling. The court specifically left open an attack based upon a state law theory of an alter ego challenge, which is very, very similar factually. And they said, but in the case of an alter ego challenge or actual fraud, a la Tom Petters, we may revisit this consolidation with a non-debtor. There has only been one Court of Appeals in the country which has permitted the assets of a non-debtor entity to be consolidated with the debtor. So that in and of itself is extremely rare. And that case was decided by the Ninth Circuit several years ago. Since then, in September of this year, not involving a nonprofit, there's another Ninth Circuit opinion that also, I think, really, really restricts the availability of substantive consolidation. And in that case, a Chapter 7 bankruptcy trustee tried to consolidate the assets of multiple non-debtor entities that were related to the debtor that he had been appointed to administer. And the court, the Ninth Circuit ruled that because the trustee had not provided notice to all of the creditors of the targeted entities, that substantive consolidation wasn't proper. So I read that case and then I take a step back and say, well, my God, in the Archdiocese case, to follow that case, the committee would have had to have provided notice to every teacher at the high schools, every employee at every foundation, Xcel Energy would have been bombarded with notices. Just the administrative costs of going down that path makes it difficult, if not impossible. That issue wasn't raised in the Archdiocese case, I suspect because none of us were smart enough to think about it. But it's in our quiver now. So subcon is probably, a stretch for sure in the states in the Eighth Circuit. Interestingly, in the USA Gymnastics case, the creditors committee there has begun to saber rattle a little bit with a threat of a substantive consolidation proceeding, and they've been careful to point out in their moving papers that the Archdiocese case decided by the Eighth Circuit isn't binding upon them in the Seventh Circuit. So, this isn't the last word, but it gives us a lot of comfort locally.
So I'm just watching our
Okay.
time. So I want to make sure we talk about then sort of some of the practical considerations of this, because ultimately here we're thinking, how do we avoid a successful substantive consolidation motion or an alter ego challenge? And Phil touched on this just a titch, but the important piece here is that the organizations are failing to respect the difference between the operating charity and the foundation. So really looking at, and put it in a positive way, have they really respected the fact that these are separate organizations? So the kinds of factors, and it's really looking at holistically everything. Were funds commingled? Was there fraud or insider preferences? Did we not respect the corporate structure? Do they not have separate boards of directors, for example? Is one of them insolvent? Is there control? Have they, respected corporate formalities that if, there's going to be a transfer from the foundation to the operating charity, did the foundation actually have its board approve it and then transfer the funds and it shows up as a debit on one book and a credit on the other book, those kinds of things. Looking at sharing of assets and employees between the two. How do they hold themselves out to the public? Does it look like it's one organization, or is it clear that they're two? Those kinds of questions.
It's important to remember that no single factor is going to be determinative. It truly is the scales of justice, and we're going to put pebbles on each side of the scale, and I can't tell you which one tips it one way or another. The one that I think probably is the biggest stone, which is probably a rock, is commingled funds. And even I've told clients to return donors' checks and ask them to make the check payable to the foundation and not run the check from the donor through the operating charity's deposit account. Just don't do that. And that's the one that makes the hair on the back of my neck stand up.
We talked about this. So just some practical considerations as we think about this. It's just, if we're concerned that this is going to be coming up, of course, paying attention. I'm going to flip back to that slide for a second. So this is the factors that get looked at in a alter ego or substantive consolidation motion. If you were calling today saying we have this separate foundation, we're worried this thing might happen in the future. Let's get our acts cleaned up now. Which, by the way, we've been doing a lot of this recently. It's really that attention to detail and making sure things are truly separate. Looking at solicitation, because often that fundraising is done jointly, right? I mean, if it's a Catholic organization, for example, the bishop is highly involved in soliciting funds for the foundation that supports all the great work that's happening in the diocese. Well, making that clear, who's doing the fundraising, and when you make a gift, it's going to the foundation, or is it going, in that example, to the diocese? Really looking at those corporate formalities. How much board overlap do we have? Do we need to have as much as we do? Might it be that we could accomplish what we need to have the good, strong connection between the two, but maybe we only have one or two board members who overlap? Looking at, what services are we getting from our operating charity, and do we have good written agreements that document and evidence those, just as we would if we were getting those services from a vendor. Are we paying for those? Are we paying fair market value? This is an example of a situation where quid pro quo is a good thing. It's a fair exchange. It's not a gift that could be clawed back or makes it look like, you know, we're kind of disrespecting that boundary between the two, but instead it's a contract, just like we would have with a vendor. Those kinds of formalities come into play and are extremely valuable if there's a challenge or a question raised about the separateness of those two entities.
And as you get closer, as Chapter 11 is looming, there are a few additional suggestions we would have. Number one, if you've got a separate foundation, take a look at how you plan to manage that process in that case. We've recommended that the board establish a bankruptcy committee. Mm-hmm. You know, take a look at your conflict of interest policies, because if you do have overlapping board members, the board members, which are also officers or directors or board members of the debtor, probably at a minimum should recuse themselves, because they will, when they file their bankruptcy case, they will owe fiduciary duties to the creditors in the bankruptcy case. That may be difficult to accomplish if one of those overlapping board members is the bishop. And they've done that. Third, and this isn't a pitch to hire lawyers, but it is a pitch to hire lawyers. Get your team assembled early, because one of our clients commented that even in a market the size of the Twin Cities, when the Archdiocese of St. Paul filed, experienced Chapter 11 bankruptcy lawyers were gobbled up about 6 weeks before the case was filed. And we have conflict rules, and we declined a number of clients because of conflicts. So you need to assemble your team early and make sure you include a crisis communications person on your team. Finally, I mentioned this earlier, but the bankruptcy rules permit incredibly broad discovery from third parties. There's a bankruptcy rule called Rule 2004, which essentially permits a creditors committee to ask the court for an order requiring third parties or any person to produce records. There's the most recent evidence of that I saw is in the pending case in Santa Fe, New Mexico, where the creditors committee served upon the foundation a request for business records that included all, and I'm reading here now, all documents evidencing donor restrictions for funds greater than $10,000. Okay? All documents. So purge your files for that. All communications between the Archdiocese and the foundation going back 6 years. All transfers from the Archdiocese to the foundation forever. So you can, as you're sitting here, you can say, well, gee, how many man hours is that going to take to accumulate? And those are the provisions of the order that were agreed to by the foundation.
The other thing, just thinking ahead, is then, we talked about the corporate formalities and protecting a separate foundation. Whether you have a separate foundation or you're the operating charity yourself, the other piece is getting back to Cheryl's comments is this is a really good time to make sure your gift instruments are as clear as they can be, that your gift files are robust, anticipating that there could be these kinds of questions, and so having a good document management system that can, tracks what gifts are restricted, what are the nature of those restrictions, where is it documented, and then for raising funds going forward, obviously having good, robust practices around execution of gift instruments and filing and retaining those will serve the organization really well.
And good hygiene around, if there's the separate foundation idea, sort of that good hygiene around being intentional about where is the gift going? Is it going to the operating entity to do something there, or is it going to the foundation? with restrictions, you know, from a protection standpoint. So being cognizant of just really good hygiene around your practices and when you've got the separate foundation, those relationships on an ongoing basis, not just when you're in the soup or think you might be in the soup.
So I think we've now demonstrated why we have three of us up here. and why we move down parallel paths sometimes and have a lot of conversations and email exchanges. It truly is an emerging area of the law, and we are going to see, my prediction is we will see continuing developments as New York has opened a statutory window for abuse claims for 1 year, running through the end of the year. California will be open January 1 for 3 years. So we're going to be seeing litigation involving those Catholic cases for years to come. So I've told Sarah if I were 50, there'd be a career here. But 50 is a long way in the rearview mirror for me.
So with that, we'll close. And I don't know if people still have questions. People online, you can send your chat. We'll be around for a little bit. And with the online folks, if we can't get to your questions, we'll answer.
Contact info on the materials.
Yeah, we can follow up. So with that,
Thank you.
Thanks for coming.
Terrifying.